SJC-12547 Craft Beer Guild LLC v. Alcohol Beverages Control Commission, and SJC-12595 Rebel Restaurants, Inc. v. Alcohol Beverages Control Commission.
Mr. Dickinson, good morning.
Good morning, Chief Justice. Mark Dickinson for the appellant, Craft Beer Guild, LLC. This is an appeal of an administrative decision by the Alcoholic Beverages Commission. The ABCC, by a decision of February 11, 2016, suspended my client's license for 15 months for violating 204 CMR 208 in General Laws, Chapter 138, Section 25A. I'd like to focus on Section 25A because this appeal concerns the vitality of Section 25A. And we would submit, given the circumstances in this case, that when first brewed up by the legislature in 1946, this statute was a potent anti-discrimination statute that had two components, an anti-discrimination part and a part that prohibited inducements and also rebates and discounts of any kind except for one certain class. And unfortunately, over time for the ABCC, this potent statute has grown to be like a stale beer, a watered-down beer. Essentially, in 1970, the statute was altered, and the part that is applicable today, subsection B, was completely eviscerated. That was the statute, the portion of the statute that said that it was prohibited for any licensee to grant directly or indirectly any discount, rebate, free goods, or allowance. That was deleted.
It doesn't go on, it talks about a certain percentage, doesn't it?
Except a discount not in excess of 2% of, yes, it talks about a certain amount of discount.
Doesn't that matter a little bit? That when they got rid of that, that was pretty particular, that 2%, right?
I suppose it was, Your Honor. I mean, it was, that language, I would speculate, was originally enacted to give the ability of wholesalers some ability to discount, and so it was tightly regulated up until that time. And with the repeal of that part of the statute, essentially the legislature spoke and said, we are going to allow any discounts. And in fact, in decision, the Van Munching decision authored by Justice Lenk when she was on the appeals court, essentially that Van Munching court determined that it was improper for the ABCC, who at that point in time was trying to prohibit discounts generally by the Van Munching company that was seeking to allow volume discounts on Heineken beer, to improperly rewrite this section back in.
I defer to Justice Lank on Van Mushin, but wasn't that a case in which there was a uniform discount? And right, that was disallowing a uniform discount.
True. It was, there was no allegation, you're right, there was no allegation of preference or
right. We have differential discounts.
Right. So what's your definition of price discrimination?
Well,
25A.
I think it's sorely tested at this point in time. I think it has to be discrimination on the retail price paid by the retail license, a Section 12 licensee or a Section 15 licensee.
For the same product?
For the same product, same kind.
The client charged the same price to the same people for the same product?
It's alleged to, in this case, it did. It did. If you look, well, if we don't really know, actually, because what is not in this record is the actual retail prices that the Section 15,
even take into account the rebates?
I don't think we can,
So if you take into account the rebates, they weren't charged the same price.
I think it was improper.
Or inducements, whatever you call them.
It was improper for the ABCC and then the Superior Court to take into account the so-called rebates, because the rebate, there was no substantial evidence that those rebates ever made it to the Section 12 license.
So if I own a bar and Justice Kafka own a bar and he gets a rebate and I don't, aren't we paying different prices for the same keg of beer that you sell to us?
Absolutely, but in this
Okay,
case.
that's not price discrimination violations?
If you had different, well, I don't think in this particular instance, because it depends on what your definition of price is, and if we're.
That's why I asked you that to start.
Right. It depends on whether, and unfortunately, the way the legislature spoke, it said that the prohibition against giving rebates and giving different rebates.
And putting that aside, the rebate portion of the statute, I'm talking just about the price discrimination portion of the statute.
But
And I'm
just
trying to
price.
get your best answer on why you haven't violated that.
We have not violated that because there's no evidence in this record that the rebates that were paid, they went to unlicensed marketing companies. There's no evidence in this record that it actually made its way to the licensee.
Even though they're the same entities,
They're not the same entities on this record. They're
same people?
They're not, well, there's commonality, there's some commonality on this record that the marketing companies were.
Are we to assume that there's something going on with the nefarious ways these things are built in the false invoicing?
I don't think you can assume there's something going on. I think that.
We can't call that consciousness of guilt like we do in the criminal sphere?
No, I don't think you should find that in this case, and let me tell you why. First of all, Section 25A, the statute that we're looking at, talks about discrimination amongst licensees. When the legislature wanted to be clear that they didn't, that they want to go beyond the corporate form and wanted to look to the corporate shareholders, they have done that. They do it, for instance, with regard to package stores. Package stores have a limit. Right now, I believe the limit used to be 3 licenses, could be owned by one company. Now it's up to 9. That's going to increase. The language they use in that context is they say no person, firm, corporation, association, or other combination of persons. And so this court, in the Seagram's Distillers Alcoholic Beverages Control Commission case, said it's a basic tenet of that a corporation is a distinct legal entity from its shareholders. So the fact that my client.
So I can understand you. On the price discrimination portion argument, your argument to us is that if we look at the record, it's a sufficiency of evidence issue under 30A.
Yes.
If we look at this voluminous record, we're not going to find it.
You're not going to find that the rebates paid went to a Section 12 licensee in violation of 25A. You're going to find, with the slight exception of Rebel, because they were a marketing company in a sense and a Section 12 licensee, with the rest of the record for which we had a 15-month license suspension, large part the record shows that the monies paid went to unlicensed marketing companies, which were separate and distinct companies than the actual Section 12 licensees. And that's what caused the ABCC. We were the first hearing out. About 6 months later, there was a series of hearings the ABCC held on the exact same record, same violation report, where they found that there was no violation of the regulation because, see my time's
That's all right.
slowly
You
coming to
still
it,
have-
but there's no violation of the record with respect to those licensees because they found that the amounts that were paid out to the marketing companies never made it to the actual Section 12 licensee.
Now, the violation was of 204 CMR 2.08, correct?
Correct.
So I gather that was once, I think, Article, whatever, 37, but that was enacted in 1935, was it not?
That's correct, Your Honor. Mr.
In
Kiley,
1935, that was before there was any 25A.
That's right. And so we would concede, given that set of circumstances, which actually came to light after we argued before the Superior Court, that Section 24 likely was the authorizing authority at that point in time. But as Mr. Kiley will make clear in a moment, if I give him more time, I would get into it as well. The legislature, by the repeal of Section 25A, Subpart B, made it clear that that regulation has no vitality any longer.
Let me make sure that I understand your position. You agree that the regulation at issue was, when it was enacted pursuant to Section 24, no doubt pursuant to the provision of for the proper and orderly conduct of the licensed business.
I think we have to concede that point at this.
And do you also concede that this particular regulation preventing essentially payoffs and kickbacks was an appropriate exercise of the agency's, the commission's authority with regard to the regulation for the proper and orderly conduct of the licensed business?
I think, well, I don't know that I want to concede that point, Your Honor. It was, the pursuant to Section 24, the ABCC has wide authority, but back when they enacted that, the regulation back in 1935, they didn't have, there's a little more overview, a little more rigor to implementing regulations. And I think it's clear subsequently in 1946, when the legislature went back regarding price discrimination, they again authorized the ABCC to issue regulations in regard to price discrimination and trade practices. And then in 1970, it repealed not only the statutory language prohibiting inducements, but also the authority to issue regulations in that regard.
So if we don't agree with you as to whether or not it was within the authorization of Section 24, you can prevail only if we were to find that, yes, it was appropriately promulgated within the authority of the commission for the proper and orderly conduct of the licensed business, but that the repeal or the market revision of 25A essentially rendered it now ultra vires after that? That's what you're saying?
That's correct, Your Honor.
Why would it?
Why would the repeal have rendered it ultra vires?
Well, why should we infer that where the legislature prohibited price discrimination, why should we infer that the legislature intended to authorize bribery kickbacks?
Well, not that they're authorizing bribery kickbacks.
You're saying that you're saying they affirmatively said we don't want a regulation that would bar bribery and kickbacks.
Well, I think if you look back what they actually did, I think they were trying to loosen up, there's basically no allowance of inducements, rebates of any kind in 1970. They took that out so that they could open up the ability of wholesalers to offer different things. And essentially, they quickly in 1971 created a post and hold regime, which is presumably what their design was, to allow commerce to loosen up, allow discounts to be given, and they had this idea that with post and hold, that would regulate the market, so to speak. So I think the legislature has spoken, and it's unfortunate we're using the word authorized kickbacks, but essentially that's what they did.
Okay, thank you. Mr. Kiley.
The walk gets longer, Your Honor.
Oh, it's the same walk. You're as young as you always were, Mr. Kiley.
Thomas Kiley for Rebel Restaurants. I think that Rebel Restaurants can prevail in this case, regardless of whether Kraft prevails in this case. Because the charges against Kraft related to price discrimination under the statutes and a violation of the regulation. My client is charged only with a violation of the regulation. I do not believe that or I would assert to you that the legislative authority to promulgate Regulation 47, when it was enacted in 1935, is not as clear as one might think. And I would suggest that if you look at the way the regulatory authority of the commission evolved, it will become clear to you that the authority did not exist. So it's easy to forget.
But isn't this the core of what we're trying to prevent? Basically, selectively buying your way into, bars and restaurants.
Let me address it directly, Justice Kafka, because I think there's a sort of a real irony in trying to import Chevron-style deference and so forth to a Lochner-era regulation. So in 1933, when these statutes creating the ABCC and then giving it regulatory authority were passed, we were still in the Lochner era. And the initial regulation that, the initial statute that was enacted in 1933 in anticipation of the end of Prohibition did not contain all of the regulatory authority that the statute later in the year and in subsequent years did. The passage that the Chief Justice refers to with respect to regulating the businesses existed, but not in Chapter 120 of the Acts of 1933. But it did not exist in the version, and it continued to exist, but the provision that dealt with pricing did not. It was not in Chapter 120 in 1933. It came in Chapter 376 in 1933. And the regulation, when it came in 1935, again, it's sort of the birthplace of the era. But the pricing provision that was inserted in 1933 into the regulatory authority by Chapter 376 only extended to maximum prices. In the Lochner era, freedom of contract prevailed. The rule of the land
But
was...
even in the Lochner era, we didn't want payoffs to bars so that you use one product versus another, right? I mean,
In the Lochner era, we didn't have bars. In theory.
Well,
In theory.
depends on when the Lochner era.
1907?
And in truth, Justice Gaziano might have gotten a free beer in some of those institutions where you would not have Justice.
We're going beyond the record here.
Yeah, we are, and I apologize.
I won't dispute it, though.
Going back to Justice Kafker's point, I mean, the language I'm referring to, Section 24, is for the proper and orderly conduct of the licensed business.
Yeah, and it was there in Chapter 120, Chief Justice. But later in the year, when they wanted to deal with pricing, they put a specific provision in the regulatory authority dealing with pricing. And it established the ability to establish maximum pricing. One wants to infer here that in 1935, the authority also, the ABCC, also had authority to promulgate minimum pricing, minimum standards when the statute says maximum. So that's a point I want to make.
But
Another-
I think, though, uniformity I get, and maybe in the Lochner era, we didn't want minimums and maximums, but when we're starting to talk about sort of discriminatory behavior,
In 1946, Your Honor.
with those,
In 1946, the anti-discrimination provision comes in.
well, but it's not, the discrimination in, we're not talking about, discrimination in we're talking about basically pay-to-play stuff. And I can't imagine that's any different in that era than this era, and the ABC in particular is supposed to prevent that kind of stuff. Isn't that right at the heart of what they do, and the heart of what that original CMR in 24 said?
No.
Really? Okay.
No, in a word, in every commercial transaction, everyone, price is a factor. It's how a seller convinces a buyer to buy, every one of them. Freedom of contract, freedom to establish price was the law of the land. The notion of uniformity and discrimination was not in the picture in 1933. It
So you're
comes
saying
in
that was not-
1946.
In other words, that was not part of the regulation? You're saying that was not part of the regulation?
No, the Regulation 47, or Rule 47 it was called, came in 1935. The
1935.
anti-discrimination provision came in 1946. And the inducement provision, if we want to call the portion of the reg a uniformity provision or a discrimination provision.
regulation.
That was in starting in 35.
Okay.
But again, the question came, well, what about the percentages, the 2%? Again, the rule of the land in terms of quantity discounts, it's in the Uniform Sales Act. It's not verboten as a matter of law to provide quantity discounts. But to Mr. Dickerson's point, the chief is puzzled by my answer.
No, I'm just trying to get back to, you're charged only with Section 208.
I'm charged only with 208.
I understand your argument that says you are outside the scope of 208 even just because you received it as opposed to gave it. I get that part. But your historical, do you agree that in 1935, when this was enacted, if somebody were to say to somebody at a bar, here's $100, make sure that your boss only sells Schlitz, that would be a violation of this? It would be a violation for the
Yes.
person to pay the $100, or a violation for the Schlitz guy to say, go ahead and do it?
Yes.
Okay,
Yes, I
so there
do.
is this provision which bars the payoff so that this particular bar will only sell Schlitz, or Rheingold, or whatever, the Schaefer, or
Well,
Budweiser.
we are dating ourselves.
I understand.
The,
Age of craft beer, this was,
in your hypothetical, somebody pays somebody to say, make sure your boss only sells Rheingold or Schlitz. It isn't that somebody says to the bar owner, your price is X. And that is what happened in the case of Rebel. And I think, to Mr. Dickerson's point with respect to the statutory history, it is wrong to look at the statute without looking at what occurred in and the regulation, without looking at what happened in 1971 as well. In 1971, the legislature enacted a law, put it into 25A, that provided for, he called it post and hold, price quotations. And it said it is discrimination if you don't hold to a price quotation for a period of 30 days. In my client's case, my client was offered a discount, a rebate, not a bribe, because it was offered to my client. My client accepted it, and my client was entitled to rely on that for a period of at least 30 days, lest it be discrimination. I revert to Chevron, because it's what I learned, right? And Van Munching and Judge Raschudi's decision talk about the two-part analysis. The legislature has spoken clearly with respect to discounts and rebates, and has eliminated, as Mr. Dickerson notes, not just the prohibition that was in B, but the ability to regulate with respect to the subject matter that was in it. Again, we talked about what was the regulatory authority originally. Well, when in 1946, again before any of us were born, when they promulgated the statute in 1946, they bestowed authority on the ABCC, not in some vague general terms, but specific authority to adopt regulations under 25A and B. And in 1970, they repealed that authority. The statute didn't just eliminate 25A small b. The statute eliminated the rulemaking authority that existed under 25 capital A and 25 capital B. The legislative intent in 1970, when it was repealing those provisions, could not be clearer. It is unambiguous. And frankly, had there not been a need to provide that pricing authority in the 46 statutes, they would not have had to insert it in the 1946 statutes.
So going back to my example, you're saying that when they repealed and limited the scope of 25A, my imaginary guy who was going to pay $100 for you to use Schlitz, that now was permitted?
No, what I would say to you is that might have been prohibited under the commercial bribery statutes. But in terms of whether it was provided, the notion here that
Saying that which might be commercial bribery, the legislature intended to bar the ABCC from doing under Section 2.08?
almost, what I'm saying to you is we have statutes that deal with commercial bribery, that deal with those three-party transactions. The transaction in this instance is a two-party transaction. When you say to somebody, no, you have to give them a price quote, you have to stand by that price quote, and those people give you, bar owner, a quotation, you are entitled under the regulation to accept this. The notion of uniformity and non-discrimination is not applicable to Rebel. Rebel isn't offering things at a different price. Rebel is accepting the price it is offered with all of the terms that come with it. In 2017, when the 1935 regulation has never been enforced against a retailer in the history of the statutory scheme. And we know that because the ABCC, who we're asked to defer to, responded to public record requests that are at 313 and 315 of the record appendix, and they had no evidence whatsoever of any enforcement, any advisories, any rulings of any kind in the entire history of the existence of Regulation 47. So,
Mr. Kiley, can I interrupt you?
of course,
Your brother, albeit reluctantly, said something along the lines of the legislature essentially authorized kickbacks. Do you agree with that?
no, I don't think it's every rebate is not a kickback.
How about if they're done really quietly and they are not recorded properly?
Well, again, if we had a statute that prohibited bribes and kickbacks, I would suggest to you that you might have evidence of consciousness of guilt if that's where we're going. But in a world where discounts are permitted, where coupons and rebates exist everywhere, and a willing seller quotes a price to you, I'm suggesting you are entitled to take that price with all of its features.
No.
When the card, I'm sorry.
The false invoicing just doesn't look good.
No, I agree it doesn't.
Right, so I mean, that's like, I think goes to Justice Link's point, it's like,
But-
so I
may I-
know there's all this ambiguity about 1935 and 1937, but the bottom line is the retailers have said, this is some shaky business, so we have to dummy up these invoices. That's how I read it at least,
Of
but you'll
course.
tell me how you read it.
And I'm going to tell you how to read the invoice, as you know I will. What does the invoice say?
Menu consultants.
It says, please make your check payable to Rebel Restaurants, Inc. That is the licensee. So the idea that there is a third party here is just wrong. We don't have a quote-unquote marketing entity. There's no organization, there's no corporation, there's no other association. We are, the craft came to this entity, and the evidence is present in the Kraft case, and said, here is your offer, and asked them to be invoiced along the way, after the fact, which I guess can enable one to say, is that a kickback? What I'm saying to you is it's a quantity discount, a rebate that is being offered to the entity.
But what about the services rendered deception? Is that, and maybe I'm conflating your case with another client.
There's no,
Another.
I think you are mixing it up.
You didn't have menu consultants and all that.
Well, there is, menu support is on the invoice, Your Honor, if that's what you're asking.
Okay.
So, again.
Menu support?
I think the
I think
justice
that's right,
said,
but I'm just saying, what is menu support?
I don't know.
Okay.
But I'm not suggesting, well, here's what I will suggest to you, I'll say it blatant, right out. This statute is not about record keeping. There's no duty anywhere established for us, for this entity. This isn't a mail fraud statute. We're not fooling anybody. There is an invoice that is requested, that is provided, that reflects a business transaction that is totally consistent with the way the legislature has prescribed the operation of the law. There's no regulation at the ABCC that deals with how one invoices. There's no statute that deals with how one invoices. And the way I label my bills, and what if I put down litigation support, who knows what that means either, Your Honor, to be perfectly blunt. So we misled nobody with respect to it. Those invoices go nowhere other than to the willing seller who has given us an offer which we have accepted.
The invoice doesn't suggest a third-party marketing entity?
The entity up at the top, Justice Lowy, that Rebel Restaurant Group, Inc., doesn't exist, does not exist. In all of the other transactions where no violation is found, there is a third party. There is no third party in our transactions.
There's a finding, isn't there, that Rebel Restaurant Group, Inc. exists?
I think there is a statement, an assumption made by the trial court that there was. I think if you will look to the record, there is a statement that is made by Investigator Velez about them being a marketing entity, and immediately after it, the chief investigator, Mr. Mahoney, corrects him and says that all that we can really say is that they're not in the Secretary of State's corporate database. There is no entity to that effect. So to the extent that there's no substantial evidence that would support any finding along those lines, Justice Seifer.
All right, thank you.
Thank you.
Mr. Hanson.
Good afternoon. May it please the Court, Assistant Attorney General Kirk Hansen on behalf of the Alcohol Beverage Control Commission. The Commission's decisions against both Kraft and Rebel should be affirmed. Because even after the repeal of Section 25A, subsection B in 1970, the regulation 204 CMR 2.08 still is a valid and enforceable regulation, and the commission did properly find that both Kraft's conduct and Rebels violated that regulation. Now, we've been talking, I want to start just by why that is a valid regulation and still is, even after the repeal of subsection B of 25A. Going back to Chief Justice Gantz's point, this regulation was enacted in 1935 pursuant to the broad power that was in Section 24. Section 24 giving them the power to make regulations regarding the proper and orderly conduct of the licensed business. And as this court recognized back in the Nealon Liquor case in 1962, the Liquor Control Act is a police power action to make sure that there is to stabilize business, avoid price wars, and instill observance of the law, protect the public. This regulation does two things. The first was that it prohibits any licensee from giving or permitting to be given money or anything of substantial value in any efforts to induce a person to persuade another person to buy a particular brand of alcoholic beverage. It also prevents providing a direct payment to someone to not buy a particular brand of alcoholic beverage. That's clearly consistent with this broad power for a proper and orderly conduct of a licensed business, as we've been noting. If this type of conduct was permitted, you allow bribery, you allow unfair competition. It's very clear that it's consistent with that policy. The statute.
Before you leave that point, so going back to my example, instead of the $100 going to the bartender to persuade the owner to do it, the money goes directly to the owner. That's not a violation now of the reg because there's only two parties, not three.
I think if the money is simply to have the owner, the license holder, buy the beverage, the beer directly from the wholesaler, I think that is permissible and not a violation of the regulation because the regulation is looking for these three-party transactions. On the other hand, if the hypothetical was a direct payment to say buy anything but Schlitz, that would be a violation of the regulation. But if it's saying I'm going to pay you $100 to convince you to buy my beer and it's directly to the license holder, that does not appear to be a violation of the regulation. And I think that is what then gets into why Section 25A was enacted in 1946, because that was
I'm
looking at
confused
the-
by, before you leave that, so they can pay $100 to the owner of the bar and not violate this? I'm confused why that's the case.
Well, I think if we're looking at it historically, I think there's a three-party transaction, and if the owner of the bar is the license holder, I think, again, if the license is being held by a corporation and you're talking about the president of the corporation who may be able to direct the corporation to do this, that can then become a three-party transaction. So there is that issue of who is actually the license holder, who is making the purchase. So if it is just the owner, that could be a violation if the owner doesn't actually hold the license.
So if Pat runs a sole proprietorship and you pay off Pat, it's not a violation, but if Pat incorporates and you pay off Pat, you have a violation.
I think this is the issue of, it didn't violate that regulation, but this is what then led to this issue of, in 1946, with the passage of Section 25A.
Well, can you just go back to where you were a moment ago, though, because you had started out before you got some questions on 24 CMR 2008 comes from Section 24 and not Section 25, and you were going to list the two purposes of Section of the CMR as it relates to this, and you didn't finish.
I thought I did. I mean, the simple
But
fact
what
that
you talked about-
what I was saying is that the prohibition is consistent with the purpose of Section 24 in these two different issues, because you're trying to prevent corruption, you're making sure that you have open and fair competition, it's
Right.
all above board. That's consistent with Section 24. Now, if the money is being paid directly to the owner, that does become more akin to, is it a discount? Is it a rebate? Some type of inducement that affects price. What happened in 1946 is the legislature, and I think if you look at both at the title and the preamble to Chapter 304 of the 1946 Acts, this was titled, "An Act to Prohibit Discrimination Between Licensees Authorized to Sell Alcoholic Beverages by Eliminating the Practice of Manufacturers and Wholesalers and Granting Discounts, Rebates, Allowances, Free Goods, and Other Inducements to Favored Licensees And the preamble said that the practice of manufacturers and wholesalers in granting discounts, rebates, allowances, free goods, and other inducements to favored licensees contributes to a disorderly distribution of alcoholic beverages. So the legislature presumably recognized there was this issue of it going straight to the license holder.
I'm confused, just, I'm looking at if Schlitz, is Schlitz a licensee?
Presumably Schlitz is maybe a licensed supplier or manufacturer.
Well, I'm just reading the regulation. No licensee shall give or permit to be given money or any other thing of substantial value in any effort to induce any person to persuade or influence any other person to purchase or contract for. So that's where you're getting this third party, is that? Yeah.
And going back, because we do have a three-tier system in Massachusetts, there are the suppliers, manufacturers that have to sell to wholesalers. The wholesalers then sell to retailers. If the manufacturer or supplier pays the money to the wholesaler and then the wholesaler feeds it through to the retailer, that could be a three-party transaction that violates the regulation. In a direct point-to-point sale between two licensees, though, if those are the only ones involved, those are the only two parties, it doesn't meet that three-party necessity of the regulation. But when they passed 25A in 1946, the whole key was to eliminate differential treatment of favored licensees. And so it accomplished that through two steps. The first is subsection A, which is what prohibits discrimination either directly or indirectly in price, in discounts for time of payment, or in discounts on quantity or merchandise sold between one wholesaler and another wholesaler, or between one retailer and another retailer purchasing alcoholic beverages bearing the same brand or trade name and of like age and quality. The second part, subsection B, is what said, you shall not grant directly or indirectly any discount, rebate, free goods, allowance, or other inducement except for the very specific percentages that were listed out. So they wanted to make sure that you didn't offer anything except very specific discounts.
So that gets repealed.
And then that gets repealed. And so, because again, the entire purpose.
Now, what's the impact of that action by the legislature on the existing regulation? That the other side argues that your enforcement is inconsistent with the legislative intent as evidenced by the repeal of 25A-B.
What the commission says, and I would say, is that the statute is focusing again on the actual discounts being provided directly to licensees. It is not looking at three-party transactions where you might be having bribes or kickbacks going to bar managers, to spouses of owners, or those types of three-party transactions. It's focusing on direct sales. And so once subsection B is repealed, that opens up for a wider range of discounts and rebates to be offered as long as they are offered uniformly to all, they're available for all licensees who purchase from you.
So the only vitality left is the anti-discrimination section.
Well, no, I think that's, again, because the anti-discrimination, we're talking again about point-to-point. Section 25A is not looking into commercial bribery and those types of other conduct, which is clearly prohibited by the regulation. And so you have to determine that in passing 25A in 1946, did the legislature unambiguously intend to invalidate that portion of a regulation that looks to prohibit bribery and these types of three-party transactions? I don't think that's at all clear from enacting something that is simply trying to ensure no discrimination in direct point sales between a wholesaler and various retailers. So that's the key to remember, that they have to show there's an absence of any conceivable grounds upon which the regulation can be upheld. And the regulation does reach conduct that goes beyond just price discrimination in a direct sale between a wholesaler and a retailer. I don't know if you were planning on asking a question, Chief Justice Ganser.
I'm just trying to understand. So what I understand you to be saying, and you can correct me, is that the regulation was focused on the paying, whatever, just by way of example, paying the bartender off so that the bartender will influence the owner to only buy Schlitz. But that if the wholesaler was gonna go straight to the owner and say, I'll give you $100 if you only buy Schlitz, that essentially would be viewed as a discount, and that was not prohibited by the regulation. Then you get the price discrimination statute, which says, no, that's now a violation of 25A unless you give the same discount for every beer.
Or to at least to every retailer who's
Or to every
who's selling
retailer.
That's available to all.
So you're saying that the statute was meant to fill in, the problem with the statute was, it had the three-party, and now this was now a two-party. Discrimination was focused on a two-party deal,
I think that's right, Your Honor. And so,
which is why both have to be licensed, the wholesaler and the retailer. I guess they're always licensed, wholesaler and retailers, right?
and similarly, suppliers, if suppliers are making specific payments to certain wholesalers but not others, if there's discrimination there, that also violates.
And you're saying that when they changed that, they didn't change the payoff, pat the bartender reg, they still
Correct.
kept that.
They simply wanted to authorize a broader range of uniform discounts that could be offered uniformly in sales across the board. That's what they were doing because they still wanted to make sure there was no favoritism amongst licensees in terms of price discrimination. So you can offer a wide range of prices, you can offer a wide range of rebates or discounts as long as everyone has the same opportunity to have that.
The uniformity point, where does that appear? I mean, I understand, it makes sense what you're arguing, but does that appear in the legislative history? What language are you relying on?
I don't know if it appears directly in the legislative language. I think that is a point that can be gleaned from reading the Miller Brewing Company appeals court decision that's cited in our brief. And also, if you just think about it in the context of the statute still prohibits price discrimination. It prohibits direct price discrimination and indirect price discrimination. Clearly, rebates, even if it's not the quoted price, it does affect the price because it affects the total amount of money that the wholesaler gets back. So if you're going to prohibit indirect price discrimination amongst licensees, anything that affects price, which would include inducements, discounts, rebates, has to be uniform. Otherwise, it doesn't make sense reading what's left of 25A.
So going to Mr. Kiley's argument, at least one of his arguments, if we were to conclude that there were only two parties involved with regard to Remy's, or Rebel, whatever, that basically the wholesaler gave discounts to Remy itself and there was no third party, you lose.
I do think that if you don't have that third party in the transaction, if you conclude that the commission erred on that point, then the finding against Rebel probably needs to be reversed. I would point out, though, that before the commission, the evidence that was put forward was that, yes, there is Rebel Restaurant Group is the marketing company. Rebel Restaurant, Inc. is the license holder restaurant. Attorney Kiley says that there is no Rebel Restaurant Group, but no argument to that effect was made before the commission at the hearing when the evidence was being put on. So I submit that there was, based off of what was presented before the commission, sufficient evidence to say there are three parties. The fact that Rebel Restaurant Group, the marketing company, is not registered or incorporated in Massachusetts doesn't mean it doesn't exist. It just means it's not licensed or incorporated here. It may be an unlicensed corporation or unregistered corporation. It may be in a different state.
But the checks were made payable to whom?
The checks were made payable to Rebel Restaurant Group, and then they were cashed by Rebel Restaurant, Inc. So there were three parties in that transaction looking at the evidence.
And what would that group be as a matter of corporate or proprietary form? How are we to interpret what it is as opposed to simply another name on a check?
What was happening, I should also point out, if you, obviously there's two different records here. With the negotiations of the payments that Kraft was doing with all these entities, they were actually creating and adding in these third parties to create the distance and separation between Kraft and the Section 12 retailers. That's what was found in the commission's decision in the Kraft case. So if an entity is created to provide the invoice and receive the check, you've created that third party. It was found by the commission that did exist. It was a third party here. The checks, though, were ultimately cashed and received by Rebel, which is why Rebel was found to violate the regulation as being part of a three-party transaction.
So is there substantial evidence that it's a three-party transaction in the record with Rebel?
I submit so. We've cited to the various pages of both the transcript and the evidence that supported the findings that the
So now,
commission.
what if the evidence what in the record is conflicting? Your brother said that somebody called it a marketing agent, and then somebody else corrected that.
I think what they,
Is there a finding by the judge, or how do we resolve that?
well, there was a finding by the commission. Give me 1 second, Your Honor. So I can find the,
I thought that the parties had pretty much stipulated to the evidence, had they not?
there was a stipulation to the evidence in the Kraft case. So Kraft stipulated to all the facts as stated in the investigator's report. In the Rebel case, there was no stipulation as to the evidence as presented. So it had to be weighing all of the evidence that was presented before the commission. The testimony that was said regarding, let me see if I can find the page very quickly. Yes, and so the testimony that my brother was referencing is on pages 240 to 241 of the record appendix in Rebel. That's the transcript. And what he was saying is yeah, I mean, I could read it for you, or you can just read it at your own leisure.
Yep.
All right. But that was the testimony about it. I don't think they were saying that the entity did not exist, simply that they could say that it was not registered in the Secretary of the Commonwealth's records. So that's the only point that the chief investigator was making.
So then you still have Mr. Kiley's point that the permit to be given should not be interpreted to mean receive, and that it never has been interpreted by the ABCC before to mean receive, that you've never gone after Pat.
Well, as we said, the question is whether or not the interpretation that the commission has is patently wrong, unreasonable, arbitrary, whimsical, or capricious. Respectfully would submit, certainly there could be more clear language that says the words receive, but to say that if someone accepts money that has been given as an inducement to get someone to buy something, it's not unreasonable to say that by accepting it, you permitted that money to be given as an inducement. It's not necessarily the most artful way to say it. There may be other reasonable interpretations, but the question is the commission's interpretation of its own regulation patently wrong, unreasonable, arbitrary, whimsical, or capricious? That's the standard under the Goldberg in all cases talking about agencies' interpretations of their own regulations. We would submit that it's not patently wrong or unreasonable.
But don't you have a problem with the third party? So I'm trying to figure out, no licensee. So your argument is that it has to be a licensee under 208, right?
Well,
No
the
licensee
license-
shall give or permit to be given.
And so what the commission has said is that in this type of situation, Kraft is a wholesaler, is a licensee, Rebel, Section 12 retail licensee.
Right.
The third party, let's assume you agree, Rebel Restaurant Group, the marketing group is the third party. Kraft has given the money to Rebel Restaurant Group in order to have Rebel purchase particular brands of beer from Kraft. That's the three-party transaction that the commission found. And so the money was given for that purpose. By accepting and receiving it and cashing the check, Rebel permitted that money to be given for that purpose. And so both Kraft, in giving it, and Rebel, in receiving it, violate the regulation. They're all part of the three-party
But
transaction.
which Rebel? Rebel Restaurant Group is not a licensee.
When I use Rebel, I'm referring to Rebel Restaurant, Inc., the retail licensee. I will say Rebel Restaurant Group or Rebel Marketing to refer to the marketing group.
But if you're saying, now you're saying they're the same, and before you said,
No, I'm saying that the check was, the invoice was written and the check was given to Rebel Restaurant Group, the marketing group. Even though it was made out to the marketing group, it was then cashed by Rebel Restaurant, Inc., the licensed retailer. So they then ultimately received part of the money that was given in a three-party transaction. That was the basis by which they determined that Rebel Restaurant, Inc. violated this, but the other cases that were brought against the other retailers, there was no evidence that any of the money ever reached them, that they had any agreement with the marketing companies to share the money, and ultimately, in every single one of these cases, the commission applied the same principle, which was to focus on what was the conduct of the licensee who was being charged. And did that licensee either give or permit money to be given as part of a three-party inducement scheme?
What about that permit to be given hasn't, we're told hasn't been enforced since 1935?
Well, I think, first of all, there's obviously, we can see that there haven't been any enforcement until very recently. Certainly, non-enforcement of regulations doesn't mean you are banned from enforcing them going forward. There's a case law cited in our briefs about a period of lack of enforcement doesn't prohibit enforcement of it. I also would point out the nature of this case and how difficult it is to discover these types of conduct, where parties are using fictitious invoices to talk about services that are being performed that never actually are performed: marketing support, menu programming, printing menus, rather than actually having above-board rebate programs or payments. It's all being concealed, and there's only a limited finite amount of resources that the commission has to pursue these types of cases, to pursue bars that are over-serving patrons, that are serving underage individuals. All of that has to happen, and so it was very difficult for them to even discover this. They only discovered it because the owner of Pretty Things tweeted about it. That led to the discovery. It led to a 7-month investigation, and after all of that, they were finally able to bring these cases. So I think the concealment and the difficulty of discovering this also goes to why there has been a lack of enforcement or a lack of cases being brought.
Can I ask you to do something very simple for me? I'm looking at 2.08 for a second. I'd like you to walk me through with Mr. Kiley's client and tell me, so it says no licensee. Who is that referring to? Shall give or permit to be given. Tell me the entity I should fill in the blank on each one of these things. So let me read. No licensee shall give or permit to be given money or any other thing of substantial value in any effort to induce any person to persuade or influence any other person to purchase. So just fill in the different entities in applying that.
Well, I would submit, I think it's tricky to plug people into each point.
I think you're asking us to do that, aren't you?
Well, I think what we're saying is, this is saying no licensee shall give or permit to be given money or anything of substantial value in an effort to induce a person to persuade or influence another person. So reading that requires someone has to give money.
I know, but we're going to have to, somebody in this court's going to have to go back and do this, and it would help me.
Right.
You're saying there's a violation of this provision by Mr. Kiley's client, correct?
Yes.
Okay, so just tell me how to do that, because if you can't do that, we're going to have trouble doing that.
What we're saying is that this language is talking about a three-party transaction. I know you're looking specifically for each spot.
Yeah, don't I have to do that?
Well, that would mean that the only party who could ever violate this is the party who is actually giving the money. Now, I want to provide a different, I don't mean to ignore your hypothetical question.
You're trying to make my life more,
Suppose
I have to apply regulations to actual entities in the real world, so.
Right, but if there's a situation where a supplier pays money to the wholesaler and directs the wholesaler to give that money to the retailer so the retailer will carry their specific beer, you now have 3 licensees all participating in a 3-party scheme.
Okay, so how does that happen with Rebel?
Yeah, I think.
In this
I think
case,
you
the
better.
3
I think you
parties-
better answer Justice Kampfer's
But
question.
my point being is that all 3 of them, regardless of their position, they're not the first party in the transaction, but they're all part of it and they would all be in violation. So here,
Well, let me make it simple for you. Give me one example of how to do that with the actual facts here. Because if we can't do that, it's hard to.
Well, they have been found in violation of it, so it's hard to understand why you couldn't do this.
I'm sorry,
They've been found in violation, so, I mean, it's hard to, you have to specify, don't you?
they've been found in violation because they were having the money funneling through a third.
They.
Rebel Restaurant, Inc., I know the 2 titles are very similar. Rebel Restaurant, Inc., the retailer, was receiving the payments from Kraft because they were being fed through.
Okay,
the
so let
marketing.
me do that then. Are you saying that no licensee, meaning Kraft, or shall give or permit to be given to Rebel Inc., one of the others?
Using this language, Your Honor, it would be that Rebel Restaurant, Inc., the retail licensee, permitted money to be given, there's no party saying this, by Kraft to Rebel Restaurant Group to induce Rebel Restaurant Group to persuade Rebel Restaurant, Inc. to buy the goods. They permitted it because they ultimately received it. In situations where you can't prove the money got.
Well, do that again slowly, just go
So
ahead.
the licensee being charged is Rebel Restaurant, Inc. So Rebel Restaurant, Inc., the retailer, permitted money to be given in an effort to, and it's, who gave it? It's Kraft. permitted Kraft to give money in an effort to induce Rebel Restaurant Group to persuade or influence Rebel Restaurant, Inc.
So you're saying that Rebel Restaurant, Inc. induced itself to persuade itself to accept this?
It permitted this inducement to happen because it fit,
To itself, ultimately.
yes.
Okay.
Wow. Yeah, okay.
And that's the only way you could get them, huh?
To get to the retailers, that's being part of the three-party transaction. And I think that the point being here is where you are creating and structuring these types of three-party transactions, hiding the money to avoid, they were doing this, I think, because they knew making these offers of these rebates, I know we didn't talk about Section 25A and the price discrimination against Kraft, but I do think these payments, and they created this structure bringing in the third-party management companies because if it was done directly to the retailers, it's a clear violation of Section 25A. And so they tried to create the separation. That was the finding that the commission made in the Kraft case by bringing in the third-party companies and using this fictitious invoicing system. That's why also it was a violation of 25A or Kraft's conduct here. But yes, if Rebel Restaurant, Inc. is using a third party to try to spread this money out and not have it be clearly shown, they are entering into a three-party transaction that's intended to induce.
But they're the only retailer here because the others did the same thing, but you were not able to prove that the restaurant group paid money to the bar.
Right. Based on the facts that were presented in each of those cases, the commission tried to hold a very scrupulous attention to detail of the facts and the burden of proof. And where there's no evidence that I'm not sure these numbers are exact, but for example, Lions Group was one of the third-party management companies. And let's say Lions Group manages 6 different retail licensees. If the money goes to Lions Group, but you don't know if it went to bar number 1 or bar number 2 or bar number 3 or bar 4 or 5 or 6, the commission concluded they shouldn't be penalizing one particular bar if you can't show that that bar was clearly participating in the process or in the three-party scheme. And the only way they concluded to do that is to show either some agreement to share the money or an actual receipt of the money.
Okay,
If there's no further questions, rest on our brief.
thank you.
Thank you, Your Honor.
Can I correct one reference to the record? My brother